This is a huge proposal and would have a big impact both on the amount of money that people make and really society at large.
The FTC is on the verge of increasing your paycheck, as they are now looking to ban non-compete agreements, which studies show have historically held down wages. And this includes even for lower income jobs. So not just corporate jobs that typically have these non-compete agreements. So this proposal covers not just employees, but also independent contractors, interns, volunteers, and other workers as well. So I'm going to get to some of the details here. I'm going to show you a clip of the FTC on CNBC, Lina Khan. And, you know, she has to deal with a lot of pro-business arguments from the business network, CNBC. So I'll show you how she tackles those. But first here, this is from the New York Times. The proposed rule would ban provisions of labor contracts known as non-compete agreements, which prevent workers from leaving for a competitor or starting a competing business for months or years after their employment, often within a certain geographic area. The agreements have applied to workers as varied as sandwich makers, hairstylists, doctors, and software engineers. Studies show that non-competes, which appear to directly affect roughly 20% to 45% of U.S. workers in the private sector, hold down pay because job switching is one of the more reliable ways of securing a raise. Many economists believe they help explain why pay for middle-income workers has stagnated in recent decades. So if you can, imagine, you're in a non-compete, you no longer, in that scenario, have the ability to use the argument that, hey, I'm being offered this job elsewhere for more money. Do you want to raise my pay here, or am I going to leave and take that job? In which case, depending how much they like you and want to keep you on, because it costs, oftentimes more to train someone new, they'll then, match that to keep you. But if you have a non-compete, you can't do that. You lose that leverage over your employer. So here they're simply trying to bring it back to a situation where not only is it better for the employee, but it also increases competition, allowing new companies to come in and hire within that industry, because non-competes in this scenario would no longer exist. So, and I've showed you, it's not just, non-competes, of course, aren't the only problem. Far from it when it comes to how much power employers have over their workers. Of course, union membership rate, I've shared this a million times now. If you watch my videos for any time or for, some time, you likely have seen this graph. But from the EPI here, union membership rate and share of income going to the middle 60% of families, 1917 to 2013. So you see here, as union membership rate declines, so does the share of the overall income going to the middle 60%. And that isn't just people in unions. We're talking about all workers, because of the power that unions have over industries to essentially raise the standards for what is acceptable in the workplace. So that is still, the biggest issue here when it comes to the voice of workers. But getting rid of non-competes would definitely move the needle. So before I get to the clip here a little more, other studies show that non-competes protect established companies from startups, reducing competition within industries. The arrangements may also harm productivity by making it hard for companies to hire workers who best fit their needs. The FTC proposal is the latest in a series of aggressive and sometimes unorthodox moves to rein in the power of large companies under the agency's chair, Lina Khan. So I'm going to get to commenting on a couple other, or at least one other angle, or one other lawsuit that the FTC is engaged in, and my thoughts on that, because I actually disagree with one of the things the FTC is doing, even though largely they have done a fantastic job here under Joe Biden. But let me show you first here some comments from Lina Khan on, of course, as I said, CNBC, the business network, but this is the place to go to make the argument. So she's here making that argument. Here's a bit of this clip.
So non-compete clauses today govern around 1 in 5 U.S. workers. These clauses may have started in the boardroom, but today what we see is that they've proliferated across sectors and across income levels. So we're talking about nurses, we're talking about fast food workers, janitors, but also physicians and engineers. And we've now seen that in the aggregate, these clauses can really restrict competition, both in labor markets, but also in product markets. And so our economists calculated that collectively American workers are earning around $300 billion less because of these non-competes, and that on the whole, innovation and entrepreneurship are suffering.
Now, there's some.
So I'm going to get to a little more here. So that's the overall view around, 300 billion in wages lost per year because of these non-competes alone. But here is where Lina Khan fields a lot of these questions from the pro-business angle. So, of course, 4 minutes of this, but it's worth watching.
What do you say to some?
How she responds to all of it, because she has a great response to all of it and does a good job here at shutting down all of these pro-business positions.
Somebody the critique of this would just say, okay, there's a free market, and the employer effectively is paying for the privilege. They are paying you effectively for the non-compete. So meaning people can agree to contracts, and one of the contractual terms may very well be, I'm going to pay you a little bit extra, or whatever you think is appropriate, so that you don't go off and work for my competitor tomorrow.
Yeah, in theory, I think we've seen that people suggest there is that premium. I think we don't always see that in practice. Sometimes employers are actually imposing these on workers even after they've agreed to a job.
On that point, I'll get back to this just to share this. One study found that only 10% of workers sought to bargain for concessions in return for signing a non-compete. About 1/3 became aware of the non-compete only after accepting a job offer. The idea that these employers are really proactively raising wages because they have included non-competes is ridiculous. Only after you have maybe asked for higher pay because you see a non-compete, only then maybe they will decide to raise that pay if they have no one else for that position that they can put in that spot that would work just as well as you would. So, yeah, there is no situation where an employer is going to raise your pay just because they've included that. Why would they unless they are forced to? This is how all employers operate. They're going to try to hire you for as little as they possibly can. That way, they make a larger profit.
I think what we've also seen is that on net, this can be bad for competition in ways that we should be concerned about regardless. At the FTC, sometimes we hear from founders who were able to secure capital. They were looking to enter a market. They were able to build the factory. But at the end of the day, they weren't able to build and scale because all the relevant workers, the talent, was locked up. And I think when you look at states like California, that for decades have rendered non-competes non-enforceable, I think you can see that there can be a huge boon to innovation and competition.
What about the idea of trade secrets? So part of this, and a lot of this comes from tech, where people have a view that there are folks who are engineers or others or in healthcare who have trade secrets. They know stuff. And so you don't want them to be able to go across the street and take either the trade secrets themselves or even sort of adjacent knowledge, if you will, in the immediate term, at least, right? It's not necessarily just the trade secret unto itself. It's, you know what, even if they don't tell the other employer exactly what the other guys, they know too much, and that has value, at least in the first 6 months to a year out from that job. So we want to hold you away from having that happen for some period of time or what have you.
Look, it's a reasonable concern. And at this stage, what we've seen is that there are alternative tools to non-competes that you can use to protect legitimate trade secrets, legitimate IP. So you can use non-disclosure agreements that can be tailored. We also have trade secrets law, right? Employers bring hundreds of lawsuits a year to enforce trade secrets.
The conundrum there is that's after the fact. It's typically, when I say after the fact, it's typically after somebody has arguably taken a trade secret and used it. And so the employer has.
I just got to look at how proactive this network is when it comes to defending the profits of massive corporations. This is like, you will never see them try and make this argument on the other side, where people are getting screwed. Their wages are lower for a variety of reasons, one of them being non-competes. But when it comes to like, oh, because the employer, the company has to sue them after the fact, go after them after they discover this issue. They should be allowed to prevent them from even having another job at all. That's the solution. It's just like, I understand his position here is to push back and ask these questions. That's his job. But this is their only perspective. They never have the other perspective of the worker.
Has been quote unquote injured, right?
Which, by the way, last point on this, I've said this before. CNBC is a business network. There is no equal of that on the employer side. There is no union network from NBC. So there's NBC, which is already pro-corporate. Then there's CNBC, which is tailor-made for large corporations. There is no labor NBC. Just to give you, again, the which is, yes, obvious because we're talking about capitalism. This is how they operate. But it just to show you how they are not unbiased here. They have a perspective that they showcase, yet they are unwilling to really own that their perspective is always going to be pro-business. They pretend they are neutral when in fact they're only giving you one perspective on these issues. All right, let's finish this off.
They're having to show injury. One of the reasons they have non-competes or these type of arrangements is to prevent even getting into a position where they have to show injury first, right?
That's right. Though we've also seen instances in which people break non-competes, they go anyway, and
right.
Employers are having to enforce after the fact anyway. But at this stage, our thesis is that there are these alternative mechanisms that would still protect legitimate trade secrets, protect IP, but not have such a drag on the economy in the way that we see non-competes do.
What do you say to those who say, look, the FTC actually doesn't even have the authority to put this rule into place? It's Section 5, and we can get into details of what that is, doesn't really allow for this. And this, if ever got to the Supreme Court, especially given the politics of how you think about the Supreme Court today, that this is dead in the water before it starts?
Look, Congress gave the FTC the authority to check unfair methods of competition. They told us that we could do that through a variety of ways, through bringing lawsuits, but also through bringing rules, through issuing market-wide rules. And so we're confident that the text and structure of the FTC Act gives us clear authority to do this.
So it's very likely that there will be lawsuits over this, because anytime you're going to potentially decrease the profits at all of a business, of an industry, because of pro-worker measures, there's going to be a challenge, because all the money, all the ability to challenge these kinds of things are on the side of the employers. So they likely will try and challenge it, and they may be successful. But it is definitely, it appears to be, within their authority here to do these kinds of pro-competition measures, which, again, yes, this also helps competition along with helping employees.
There have been times where you have proposed rules, they've had a comment period, and then you have not enacted those rules. How do you think about that?
Yeah, it's a great question. So as you noted, this is a proposed rule. We've put out a proposal. We're going to be collecting comments for 60 days. The proposed rule is based on our survey of the available evidence, but we also include a set of questions that we're inviting the public to comment on. So once people have finished commenting, we're going to look at that full record and determine what's the best way to go forward. So we really encourage people, be it employers, be it startups, entrepreneurs, workers, to submit comments and help us decide how to proceed.
All right, so we will see if this goes through. Again, there's, as she discussed there's going to be a waiting period with questions that'll be submitted. Last thing I want to comment on here. So, New York Times writes, Ms. Khan has brought lawsuits in recent months to block Meta, Facebook's parent company, from buying a virtual reality startup, and Microsoft from buying the video game publisher Activision Blizzard. Both cases employ less common legal arguments that are likely to face heavy scrutiny from courts, but Ms. Khan has indicated she is willing to lose cases if the agency ends up taking more risks. So I actually like this approach, even though I will say here, I do not think their lawsuit against Microsoft in their pursuit of buying Activision Blizzard, I don't think this will be successful. It would take a whole other video for me to really, get into it. But essentially, this is not the claims being made by Sony, and I own all the consoles. I'm a big gamer. The claims being made by Sony are not accurate in terms of the power that Call of Duty under Activision Blizzard has over the entire industry. Nintendo is currently the most successful video game company in terms of consoles sold with the Switch. They don't even have Call of Duty on the platform. So you can't have Sony claiming that Call of Duty makes or breaks companies when Nintendo doesn't even have Call of Duty on the platform, and they are by far in first place. But still, I'm still glad that they brought the lawsuit forward, because it shows you they are being more proactive, more willing to challenge these sorts of attempts to, just consolidate industry. So it's good to see, and it's even better to see this rule potentially get implemented here, this bar on non-compete agreements. Let's hope they are successful, because there is very little power right now that employees have. So to have this extra bit of leverage over their employer would only be a great thing.